Okay, so it's March 2nd in Senate Economic Development. We're back from a break, back on S102, as well as hearing from FOIX on S101, two of our labor bills. And we're starting with Heather Reamer of AFT Vermont.
Thank you. I am Heather Reamer, Director of AFT Vermont. Our union represents 8,000 higher education and healthcare workers in the state. We're the fastest growing union. We doubled our membership over the last 5 years. So our union is firmly in support of all the provisions of S102, good cause for termination, no captive audience meetings. We call them captive audience meetings, but just to be clear, it's an employer mandated meeting that would discuss religious or political issues that an employee would have to come to on paid time, including it's most commonly used, but there are other types as well. The ones we hear the most about are to dissuade employees from joining the union.
And can I pause you? I can ask Damien this too, because very busy, as we noted. Do you happen to know if the language in some of the bills we have already on the wall is the same? I think the Pro Tem has also introduced a separate bill.
That's right. I forgot to put it in my notes, but and there's also a House bill that's coming out, H298, that includes good cause termination, no captives. That would include they keep employers from blocking employees from leaving their employment to go work for somewhere else,
right?
And paid mostly. So there's actually at least I do have it here. It is the Pro Tem bill is S106.
Right.
Oh no, this is no. I've got the wrong number.
Okay.
I've got the wrong number.
It is S106. You're right. And I don't know, it's a lot to keep track of for all of us. So
I know.
I just didn't know if you knew if there's like a big difference between.
I don't think so. I mean, I guess one thing I would like the committee to consider is, and I can get you the information on it, is what's the penalty for this? Because if it's just that the employer has to post something on the wall saying it's an unfair labor practice and I will not do it again, we don't think that's enough of a penalty. And there are two bills that have passed on the captive audience meetings. And we can get you more information on this as well.
They passed.
Oh no, they're in statute right now in Oregon and in Connecticut.
Oh, I see. Okay.
Yeah, sorry. No, sorry. There's two standing laws in Connecticut and Oregon that have these provisions. They have been challenged legally, but those challenges have stood up. So let me see. Backing up a little bit, and I listened to the testimony, and I thought it was great to hear from all the folks this morning. And I will just highlight, the benefits of unions, as I think Josh Wronski testified. Vast majority of folks favorable to unions would like to be in one. I think we lost membership nationally last year, and so always the question is why. And our experience has been, again, we've organized 4,000 plus workers into the union the last 5 years. When the employers use every tool in their tool case, including captive audience meetings, they usually win because they have a lot of tools to use. And so we'd like to take this one, and it is only one, and it won't necessarily totally change the landscape, but we think it will be helpful out of their toolbox. When they don't use every tool, the unions almost always win. So it really is, it's about, obviously employers have a tremendous amount of power, right? They have you and can direct your work for, if you're working full time or more, as many people are, 40 hours a week. And, that is a tremendous amount of power. And so we would like to curtail it in one small way, which was to have the no captives. And it would say also related in some ways is a good cause for termination. If you are fired for union activity, if you're a private sector worker, you can file a complaint with the National Labor Relations Board. If you're a public sector with the VLRB, and they'll do an investigation and you may get your job back, but you have to prove that you're fired for union activity, right? Which is not always easy. And so having a good cause for termination gives you another tool as well. Because most employers aren't going to come to somebody and say, employers fire people every day, right? They fire people during union drives. And they might be firing those people. They might not have fired those folks if they hadn't been involved in the union, but, so we think that's actually a good companion piece to this is to allow people to know why they're being fired. And actually, I will give you an example. So when you have a union, if you get terminated, you have the right to see every piece of information that's against you. And as a union rep, sometimes we gather that information. And guess what? The employer might have a good case for termination, but the employee gets to see it, the union gets to see it. We get to make that determination. Did they in fact commit an infraction such that it's worthy of?
It has to be well documented.
It has to be well documented.
This is the best practice.
I will tell you, recently I was working with someone who didn't have a union yet. They were terminated. Don't know who said what about them, had no access to any of the information against them. And so I don't know, did the employer terminate them for cause? I don't know. The employee doesn't know. He asked for, that information, cannot get it. Well, I don't know if you file a lawsuit. So anyway, I think the two go well together. And I'm jumping around a little bit, but I think a lot of this too, if we put it through, a social justice lens, I think the provisions of this bill become, I think, more stark. The exclusion of ag and domestic workers. I think there's pretty good evidence that was racial bias and racially based when that happened with NLR. So, if you have the opportunity to include excluded workers, that's amazing, right? And we know other states have done it, California, Massachusetts, New York.
You may have heard I'm saying this for the benefit of, our three witnesses. You may have heard Senator Clarkson ask for somebody who can give us that primer on the history.
Yeah.
And, any current efforts and, the ins and outs. So we're just definitely trying to find that witness.
Yeah, we can see if we can come up with someone who's more of a historian than I am.
Right.
So.
I mean, not that was a helpful reminder.
So what was I gonna say? And when you look at wages, all workers benefit from unions. Women and people of color benefit more because they tend to make less. And so when you say you have to have a fair wage scale based on your experience, that tends to pull up folks who have traditionally made less money. So we think I would just say we support all of these. We think they're all good measures. We think they help change the balance of power somewhat. I mean, I would still say, employers still have a lot of power. They may come and tell you you're taking away all of their power. Not true. I don't know what their testimony will be. But I think clearly these provisions have passed in other states, and their economy has not, gone away. So we think they're good measures and hope that you will pass all of them.
Thank you. But okay.
You guys have more questions? No, I should mention card check as well. I mean, one thing that's interesting about this bill is a lot of the legislation is focused on what you can do with the VLRB, the Vermont Labor Relations Board, which has mostly affects public employees.
Right.
If you're to include agricultural and domestic workers, that's great because they're not covered under the National Labor Relations Board. In the card check provision, we would like it federally as well, but we think it would be great, to have it at least for the public sector in time.
Great.
I did submit a piece of paper about some of the, I have paper copies if anyone wants them, but it's also online. You guys got it.
I believe we each have this.
Yeah, and it has links to the online one.
Right,
I can send you the one with the links behind it. And I'll correct the bills.
Senator Clarkson, sorry, and then Senator Brock.
Oh,
yeah.
Heather, it's good to see you, even if it's remote. Card check. Why do I remember us going through this in the House? I feel like we passed card check. Didn't we pass card check?
I thought the Senate passed it once and not the House.
It never made it through.
Maybe this is a question for David. I mean, we definitely passed it in the House. I remember Joey Donovan speaking impassionately about it.
David's
I mean,
saying maybe a long time ago, he could speak more to it when he's.
Yeah, there was a labor bill that we worked with members of this committee, that did pass, and I can't remember how many years ago, it was now 4 or 5 years ago.
It was
What's that?
Yeah.
It didn't contain card check, but it contained a number of provisions. It cut in half the time. The VLRB's union elections were taking like 2 or 3 times as long as the National Labor Relations Board election. So we got the time to election cut significantly, and also the union's right to information about who's in the bargaining unit. And that was super helpful, but it did not have card check in it.
Right.
I
I remember that bill. I worked on that bill. It's card check particularly, and it would be great to have somebody remind us what we actually did do. This must have been 8 or 10 years ago. And
not that Damien was here, but when he's in the witness chair, he probably has a history of these things.
And David or Damien.
Because it was my point before.
That was
Anyway, Senator, we'll find
my
out.
last pass through this committee. He was here, and that I think was close to 10 years.
Okay.
I just have a dumb question.
Yes.
I don't know exactly what card check means. Oh, I'm sorry, and I didn't mean to.
Go ahead.
miss you.
Oh, yeah, that's a great.
Okay, so that's a good question. The process generally by which you get a union is you want a majority of the employees of a defined group, right? Say they want to have an organization, right? And so if you go sort of the traditional, I'll just talk you through what we do. So, we sign up a super majority, because if you just got 50 plus 1, you're unlikely to win. So we sign up a super majority of folks, and we often go to the employer and say, hey, out of your 100 employees, a super majority have said they want to have a union. Will you recognize our union? Let's just sit down and start bargaining right now. An employer can recognize the union voluntarily. It's very infrequent, but it happens. Most of the time, the employer says, you know what? I don't believe that a majority of employees here have signed their union cards, or they were coerced by the union. And so what we need to do is to have a union election. And so then the employees in their union go to the National Labor Relations Board if it's private sector, or to the Vermont Labor Relations Board if it's public sector, as long as they're not an agricultural domestic worker, for instance. And they say, we'd like to hold a union election. During the time between when you ask for the union election and you get it, employers generally want a long period of time, and they want to be able to use all the tools to dissuade people from voting yes for the union. What card check would do, or it's called majority sign up also, is at the moment let's say those 70 other employees go to their employer and say, we want a union, the employer says, nope, I'm not going to recognize you. If card check were the rule, the employees could go to the Vermont Labor Relations Board, and the Vermont Labor Relations Board would ask the employer for a list. The employer sends a list, here's 100 employees in this defined unit. The union gives the cards to the labor board. The labor board says, checks off, 70 of them. And then the labor board says, oh, a majority of the workers have expressed their desire to join this particular union. That's their union. A lot faster process than you get a list, and it can take months to do an election.
So is the list of how the employees voted, is that given to the employer?
No.
So the employer does not have the identity of the people who voted, but the board certifies that they are employees.
Yeah.
Okay,
So
I can see why they want that.
It's a much quicker process. It takes away a lot of the tools of fear and intimidation and termination. I mean, even though being terminated for organizing a union is illegal, it happens all the time. A lot of employers would rather pay the back wages, months later, but if it did enough to encourage people to vote no, it made them afraid enough. So it's a way to sort of prevent a lot of those activities.
Thanks.
It's a good question.
Yeah.
Senator Brock.
Just to clarify, I think I understand, if domestic workers and farm workers were included, the body that would provide oversight would be the Vermont Labor Relations Board in that case.
That's my understanding.
I mean, I didn't see it here, but I wasn't really looking for it.
Yeah, no, that would be my understanding, because they're not covered under, they're explicitly not covered under the National Labor Relations Act. I would assume that the VLR.
Well, with all of the things that are in the National Labor Relations Act now, assuming that no changes were made otherwise, as far as the process, for example, of forming a union, would essentially the same rules apply. I'm not sure, for example, in the Vermont Labor Relations Act, which is directed towards public employees, would they be materially different as to what has to be done than the National Labor Relations Board requires for private employees?
What I mean, you should definitely bring in the director of the VLRB and ask those questions. But currently, I think there are 8 different laws that the VLRB oversees. One of which actually is private sector employees who, in an establishment that's so small that it doesn't do any interstate commerce. So there is a provision right now for private sector employees. I don't know if it's ever been used because it's hard to avoid interstate commerce, I think, this day and age.
No telephone calls.
Yeah, exactly.
Internet,
Exactly. So yeah, so I'm not an expert on that, but I believe that would be, I don't think, and you should ask the director, I don't think you need to necessarily change all the other provisions, because they have their set of rules about how they handle things, and they have a long history of case law.
Thank you. David, I can't remember if you said you've got cleanup. Right.
Non-union.
It's more about 101.
Yes.
Great.
Thank you. Good to be here. David Mickenberg here on behalf of Working Vermont. For those that don't know, Working Vermont is a coalition of labor unions that represents around 25,000 union members in the state of Vermont, public and private sector. So mostly here to echo what Heather said related to S102. Working Vermont is fully supportive of that bill, particularly supportive of just supportive in general, but the focus that we've had is around the good cause termination. And just for reference point on that, there is a bill that Heather referenced in the House that has a good cause termination. As you're discussing that issue in your deliberations, good cause termination has been done different ways. This 102 has an important and meaningful process. The one other state of Montana, that has done this is more simplistic, and the language that's included, if it's something you want to consider as an amendment here, basically says that you can't be fired for something that's not a legitimate business reason. And it puts some parameters on what that is. So under the current, as you know, and I'm sure you heard about, under Vermont's current law, an employee can be fired for any reason, as long as it's not a discriminatory reason as defined by the statute. And that really creates a power differential in the workplace. So it would be important. So, it doesn't say employers can't fire you. It just says there has to be a legitimate business reason for it. So happy to provide that language if it's something that you want to look at in your deliberations on that issue.
Yeah, I mean, I'll just say that I think I haven't really taken the pulse of the committee on that issue. It is one of the ones where I know we have a lot of people who want to speak on either side, and so it might not meet crossover, especially in its current form. In 102, it's really expansive and specific, and even just going through the language would probably take a whole day. But it's really helpful to know we'll be able to see other language that's scaled back to consider. And I'll be able to get the committee's temperature on that, or something more narrow in scope, perhaps for the period of organizing and decertification, or perhaps if there's some smaller piece we can bite off and leave the rest for a 2-year conversation.
Great.
I
Heather,
really appreciate that.
Heather spoke to the captive audience provision. We think that's really important, and something that will help sort of, again, provide some balance in the workplace. And I should mention, it's not just labor issues, that's our concern over it, but it's really the real focus of is not requiring employees to sit through both political and religious meetings.
Okay,
So
that's why I was curious if it's in both of the bills as political and religious, like that's Damien, but
yes,
can you speak to the religious part? Or
no.
is the political, so political is like candidates and
Oh, you mean how it's defined? Yeah, the bill defines religious, the bill.
I guess just the intent, like, so we've been hearing about captive audience related to union, pressures and
Yeah.
and labor issues. Political and religious opens up whole other categories, and if there are examples or,
Yeah, I
I
mean-
don't think we want people to be subject to that.
Yeah, I mean, I think an example could be on the religious side of things, potentially is, so for instance, in the Hobby Lobby case, which was the case that ultimately said that employers don't have to pay for abortion service, reproductive services. Hobby Lobby had a religious objection to, and I'm giving you this off the top of my head, so
Yeah.
take it with a grain of salt. Hobby Lobby had a religious objection, the owners of Hobby Lobby saying they shouldn't be forced to pay for this. It went up to the Supreme Court agreed.
Okay.
And so Hobby Lobby was, through the religious freedom, wasn't forced to pay for it for themselves. What if Hobby Lobby said, we're gonna force all of our employees to come in and learn about their version of Christianity and how it is important as a moral guide? And, that would have been, in this case, we would say, well, that's not allowed, just like saying, Senator Brock's running for president. We love Senator Brock. We're gonna make you come and sit through a meeting about how great Senator Brock is.
I might support that.
Right. Bad example.
We know Senator Brock is principled and understands that even that would be inappropriate, so.
And this probably seems more necessary in the wake of recent Supreme Court
Yeah.
cases,
Yeah.
but normally we think, oh, that's covered, like, but it's probably not.
Yeah, and in the definition of the bill, it does cover, and it's where it defines political, because it really says religious political, and then there's a provision that says political includes discussion of labor and whether to join the
Okay,
union or not.
okay,
that's
so
in there.
both political covers.
Yes,
union.
political covers, labor activity.
Among the things that are included here, under political matters, are legislative proposals or proposals to change rules or regulations. And I would think that there are certain businesses where there are business reasons why there may be such discussions. For example, we, build a certain product, we build it this way, and there's legislation pending that would not allow us to do it. And that would impact our ability to stay in business or to keep your job or whatever.
Yeah, I actually think I'm trying to pull up the bill right now, but I think there's
I'm looking at page 23, line 4, from the definition of political matters.
page 23. if I'm pulling it up.
And I could understand discussion for elections, political parties, to join or support any political party.
Well, yeah,
But the question I have is about proposals to change rules or regulations and legislative
Sure.
proposals.
so I think, Senator, it's a good question, and I think actually on page 21, it talks about nothing in this section shall be construed to prohibit. And then going on to page 22, it says that is necessary for the employer to perform the employee to perform the employee's jobs, functions, or duties. So in that context, I would say if there's a rule that has changed, if there's a law that's been proposed that changes the functionality of the employee's duties, or then that under that provision seem to be an exception. If, for instance, the business just didn't like provision or a proposal in the legislature like this one, for instance, and to go to their employees and say, we're opposed to this law, and we want you to advocate on our behalf to do that. I think that's more along the lines of what that was getting at, but I think that's sort of a saving clause. If it's actually the essential, if it's the function and duties of the employee, and it's important for them to know about a rule change or pending legislation, it seems to be that would cover that.
Or would that extend to, it's important, you know, for the maintenance of your job and the way you do it and so on and so forth, to oppose a change in laws or regulations or legislation that would alter the way you do your work?
This might be a drafting question for David, and I take your point very well, Senator. I mean, I think even more so when I think of like Burlington City Council meetings, it comes up a lot, like can people, like safety issues on Church Street, or, you know, using your bathroom as a public bathroom. Like this does certainly come up where it's really related to, you know, your safety and your job performance.
Yeah.
But I imagine too, it's all in the context of not being forced to attend a meeting.
Yeah,
so-
we're on to me, a very gray line. We're all looking at employers, but there's lots of interest groups that might want all their members to write things, or their customers, as much as I would love not having my email clogged.
Right, I think we're
But
experiencing
people
that
who
being
are
right
not
now.
my constituents.
Right.
And, you know, spending several hours last night and this morning on the phone, reassuring people that I was not taxing their fuel oil, that there is a fine line there, because employees may not know that something that the PUC is about to do might cancel their job. To say, you know, we really could use your support here, and maybe, by the way, here's a form letter, but to say, you know, when does that step over to say your job depends
Right.
on your holding our
Right.
political view? And that
And
to
I
me is
imagine- Yeah,
it's a great
we'll
one.
probably want to have Damien sort of,
Sure.
yeah.
I mean, the provision, the sort of key provision of this section, it says the employee's refusal to attend an employer-sponsored meeting that has the primary purpose of communicating the employer's opinion regarding a religious matter or political matter.
And then that's the definition.
Yeah.
The classic would be, if you are a fuel oil dealer and you want to have a meeting with your truck drivers and let them know that if this bill passes, your job is probably going to go away, would that be improper?
I guess I wonder, like, I think we could look at this definition with Damien and say whether or not to support a legislative proposal in a way, like, because when it comes to unions, it says the decision to join or support. We can keep wordsmithing it, but I think it's more like, if your opinion is, okay, this might impact you, here's the facts, you know, versus I'm asking you all to write and say, don't vote for this. There's a difference between.
I need to see the, you know, the receipt from the, the certified mail that you sent.
Right.
Because if you don't send it, it gets
Yeah.
sprayed depending on the employer, and, but on the other hand, people have a right to know that if something we're doing here is going to impact their livelihood, how they do their job. And this can work both ways. Sometimes we're trying to do things to help people.
Yeah.
And I think clearly when you're talking about employer-sponsored meetings, regardless, in any of this is paid time. You know,
Right.
I don't think we discussed it, but I don't think there's anything here that suggests that an employer could require someone to attend a meeting that they want them to attend and not pay them for the time for doing so.
Right. I think the other operative provision here is that what this is talking about is preventing employers from discriminating against, disciplining, discharging, or threatening to discipline or discharge an employee for not attending the
Right.
meeting, which
Right.
relates to political or religious matters.
Right.
So it's the use of the power to to inflict some version of employment harm on an employee who says, I don't want to be involved in that.
Mhm.
It actually, the question is like, they could offer it as a meeting, right? I mean, Heather, they could say, we're having this meeting on this important piece of legislation. We think it's important that you come. This could impact your job. Please come and we'll explain the legislation. We're gonna have our lobbyists there,
Right.
whatever it is. But what they can't do is say, you have to go. And if you don't go,
Right.
you're gonna be fired. You're gonna be demoted.
But now, what does that mean, though, when you invite an employee to come as opposed to mandating it? If you invite them, then you don't have to pay them, do you?
Well, if it's on work time, then you would have to pay them.
Well, if it was on work time,
Yeah.
but, if you invite them, say, immediately after work and you paid them,
No,
yeah,
it'll be a
if it was
voluntary.
mandatory or that presumably be voluntary otherwise.
Absolutely.
I'm looking at Heather because when we were doing the abortion amendment, there was a UVM Medical Center continuing education offering basically about understanding our, Prop 5. And I was blown away, like, how is this happening? I still have pictures of it, I think, but it was about a bill. It said you can get continuing education credits for attending this. And it was put on by an anti-abortion organization.
Oh.
And UVM was like, we hear you, but we can't limit this. We can't make anybody attend, but we also can't limit this. And I was blown away. But certainly that was already protected. It seemed like you're not forcing anyone to go, but I don't know that, already we've seen like this can happen, and we don't have a lot of tools to decide what's appropriate about it.
Yeah, I mean, I would just say the employers can have these meetings on work time with the bill.
Right.
All they can't do is require you to come and punish you. if you
Yeah.
don't. I think you heard earlier testimony from the nurse in Rutland who said they had a list
Mm-hmm.
and they made sure every single person attended one of those meetings.
Right.
And so, again, this does not limit the employer's abilities to talk to employees about these issues. It just it limits their ability to say you must come, and if you don't come, we will punish you.
Right. Or, you just come to the legislature to talk about this labor bill, that we want to have a chat with you about that.
Yes, right. And so, yeah, have private one. The private one-on-one meetings too are like especially insidious because it's very difficult to prove exactly what was said during those meetings.
Right.
And so that is also, it's one of the most devastating tools because, again, it's difficult to, for folks to say exactly what happened.
Right.
I guess I just don't quite understand what the provisions regarding private meetings might be here. Or is it that you're saying there could be no mandatory private meeting, or maybe that's specific language that I just haven't.
And employers can always have private meetings with employees. They can, right? They can investigate an incident, they can give discipline. But what we're asking for is they can't have private meetings that they're requiring the employee to go to where they discuss discuss their choice to join a union.
Or to discuss their religious or other political
Yeah.
views. And so it's not about limiting employee or employers' ability to offer this, to do this. It's about limiting employers' ability to mandate it and then take harmful action towards employees who don't want to participate in meetings, either private or public.
So when you refer here on page 21, line 11, the employee's refusal to attend an employer-sponsored meeting that has the primary purpose of communicating opinion regarding a religious or political matter, or refusal to listen to a speech. This includes one-on-one meetings in addition to group meetings.
Yeah.
So if the employer were to call you into the office during work time and say, I want to talk to you about whatever, they would be prohibited from doing so?
Not whatever, about specifically political. They said, they brought you and said, I want to talk to you about, we're a company that is very steeped in Christian values. I want to talk to you about why we think that abortion should be illegal.
Okay, now that, you know, they're not required to attend a meeting. They come into a meeting and a discussion like that starts.
Yeah.
What are the options? They would say, I don't want to talk about that and leave, and that would be protected here.
Protected, yeah.
Or they're already in the meeting, and for an employee to get up in a meeting with his boss and decide that, you know, they're not going to continue with it, I would think that'd be difficult.
You might ask, is this the primary purpose of the meeting? You might just say
Well,
like, are we talking about something else?
It's true.
I'm just thinking of the practicality of how
Yeah.
this would work.
It's true, Senator, and that's actually a very good point, and it actually goes to what Heather had been referring to, the good cause piece of this legislation. So because employees are in a vulnerable position there, because they can be fired for any reason, as long as it's not a discriminatory reason that's defined by the statute, there is a power differential there, and they may be required to, may feel the need to sit through those meetings. What this bill would prevent from happening is if they decided to leave, if they decided to not go to another meeting like that, then it would not allow the employer to discriminate against them, to discipline, discharge, or threaten to discipline or discharge. So it gives employees some ability, because right now, as an at-will employee, they can say, well, you're not coming to this meeting. Well, if we don't pass any of this, well, sorry, you're fired, you know? So I think it's right. There is a power differential in meetings, and it's hard for employees at times to say, I don't feel comfortable with this and I need to leave. So both of those provisions working together, I think, would help balance that out a bit. So,
Especially if you hear they're calling us in one by one to talk about this, you
Yes.
know, and you're like, well, I have a heads up, and I'm gonna go in trying to make sure that that's not
and in
the whole conversation.
Absolutely. And in the labor context, oftentimes it's coming in saying, well, this, you know, this is just a hypothetical employer, not a real one, but saying something like, well, the labor unions, you know, you're going to have to pay dues now, and that's going to come out of your pocket. Do you want to pay dues, or if you organize it? You're not going to get to come to me and ask for an extra few days off like you used to. You're going to have to do what the contract says and start building a case in a one-on-one situation for how terrible it is to organize collectively and form a union. Then the possibility of that happening in a group meeting as well.
Now, that though would still be permissible if the meeting weren't mandatory.
Correct.
Because can the union have a mandatory meeting to tell you how good the unions are?
There's an opportunity for new employees to be able to speak with the union about what a union does. But subsequent to that, the employer can't. I don't think there's a requirement for employee.
No, I'm just saying, most things are a two-way
Yeah.
street.
Well,
I get called into a lot of meetings that I might not want to go to be
yes.
told what I should think about things. And it's part of my job, and I can be unelected at will. But it's maintaining the power, and if you're paying the salary, you've got the power.
And provide us, yeah.
I mean, as far as I can see, we're only going to hear from Austin Davis on the other side of this.
We have other people.
Okay, good,
scheduled for
because
the
I
week
don't want to
after.
be guilty of having a closed meeting.
No, yeah. The contractors have asked to come in, the
Okay.
chambers coming in, the state.
Okay,
chamber.
the one I'm thinking about are the hospitals, because we on the other side are telling them you can't
Mhm.
raise your costs, which does get them in a squeeze when you're a public institution, and
Mhm.
you know, and you can't cut service. I mean, that's just in fairness. Everybody should have a right to be heard.
So you want to hear from the hospital
I
administrators?
think it would be good to hear from
it
them,
would be.
because
They're a major employer.
Yeah.
they're a major employer, and we are putting major pressure. We in large extent control what they can charge, what they can make, and the public has a vested interest and making sure they're solvent, so they may be, you know,
Well,
they're all
that goes
not
on a
for
number of other
profit, so they
organizations.
may be one that's caught here, and I'd like to just give them a chance to be heard.
If anyone has a specific hospital administrator they'd like to hear from, otherwise my default would probably be Dr. Leffler at UVM Medical.
And obviously there's a hospital association, Devin Green.
Yeah,
Devin Green.
Yeah,
Okay.
but it would be good to hear, you know, the health centers were brought up there,
The designated agencies would be another.
yeah. And
Center,
they depend on us for their money, so,
one thing I just want to clarify or just comment on one of your comments, that I don't know that there should be a natural assumption that the formation of a union is going to provide necessarily cost pressures on an organization or business. There
no,
could
I
be
don't
many
think there is,
benefits.
I think
Yeah.
I just, their name has been brought up. They have been portrayed as being anti-union. In a democracy, both sides have a right to be heard, and I think we need,
I think
To
people
hear
try to be careful about casting aspersions, but
yes,
you're right, they have been brought up, so.
yes, they have,
Yeah.
and not in a favorable light.
And
So,
union organizing just took place at UVM Medical, you know, without
yeah, and the,
maybe significant interference that we all heard about,
but the nurses
yeah.
broke the ground,
Mhm.
and that was not easy.
No,
But I just think we
none of it's
need to hear
Yeah.
from both sides, since we're saying we're condemning closed meetings.
Mhm. So I've
yeah.
written down Devin Green.
I think that would be great.
Senator Harris.
Just a quick question.
Yes.
On the one-on-one meetings, can an employee, say, I want someone with me in those meetings? In a meeting?
I
But
might-
if they're a union,
No,
Yeah.
whether they're union or not, I mean, it's
Well,
like,
no, no.
like people do that with medical. You
Yeah.
know, when you go to the doctor, you wanna make sure you're a member, you bring somebody with you.
Right, well, if you don't have, so if you are in a union shop, then you would have, that would be something that would be spelled out in the contract.
Right,
So
and you
could
have,
or-
you have a union
You
person.
could, if it, not always.
Yeah.
I don't think it's always mandated. If it involves discipline or something related to you or your employment in that regard, and the union would have some, there could be an opportunity for a union rep to be there. Generally, people without unions have no ability to ask for anything other than what the employer
Okay.
dictates. There's no right
Right.
that I'm familiar
have
with, is
somebody with-
that
So
anybody
it's-
would do for
yeah,
anything.
it's he said, she said.
Well, what if you record the meeting? Because I think in Vermont, one party can record the meeting, is my understanding.
Yes,
So
but-
maybe that's not right.
Yeah, again, that may be, that could be true, and I'd have to look at the recording statute to understand that if in an employee context, what I would go back to is actually around the cause piece, and like, because you're an at-will employee, doing things like saying to your employer, I'm gonna have a tape recorder in this meeting.
Right.
That would potentially cause.
It's not gonna
some-
help the relationship.
Yeah, and because as long as it's not, and I know recording meetings not a protected class in Vermont, so I think the employer could,
Mhm.
while there might be another statute that allows you to do it, they potentially could say, well, this isn't the type of employee that I want in my business.
Mhm.
So without a union, without a contract that dictates, the terms of the relationship and how you can interact with each
Right.
other, there's a power differential there for many working people, so.
Okay.
Yeah. Real quick, I know
Yeah.
Kelly has
Yeah.
just on a couple of other topics that are listed on your agenda, just on behalf of Working Vermont, and I know you're gonna come back to the workers' comp bill, but we're interested in talking about that and fully supportive of 101 as drafted and happy to engage in conversation about that bill as well, which is a broad workers' comp and UI bill.
Right,
Um,
and as we've learned, workers' comp is out of House Commerce and UI is coming out tomorrow. So
Correct,
we're-
Well, either today or tomorrow, I'm
Either
looking at the
today, okay.
schedule, yeah.
So we're receiving what might be characterized as more technical bills from the House where we could continue this conversation after House over.
Correct.
But,
That's
and
something,
Kelly's
yeah.
gonna preview
Kelly's
the
gonna talk
discussion that you all would like to have.
On workers' comp, yeah.
And the
that-
Department of Labor will probably touch on it tomorrow, so it's fair to start talking.
Yeah. And then the last piece is just wanted to stay on the record that Working Vermont fully supports and the firefighters are part of Working Vermont fully supports S73. I don't even see that as a cancer presumption bill. I see that as a gender equity bill.
Mhm.
And the fact that that we are acknowledging that the firefighting is a profession that encompasses more than just cisgendered men.
Yes, right.
So
You
I'm
appreciate
just
that.
happy to come back and talk about that when you bring that up too, but I
Yeah.
just want to say that's a really important bill that we support as well. So
Absolutely.
and
Thanks
then
for bringing
I'll just, unless there's any other questions, and these are all great discussions, look forward to more conversation about it.
Great, thank you.
Thanks so
Kelly.
much.
Thank you. I feel like I should have a name tag.
I never wear a name tag. You're supposed to, not required.
My name is Kelly Massacott. I'm here on behalf of the Vermont Association for Justice, which used to be the Trial Lawyers Association.
They have capes, red capes.
I
We
know,
should.
right?
So I've been an attorney for 16 years here in Montpelier at Bingham, Fox and Skinner, basically doing mostly just workers' comp, a little bit of social security disability over the years, but my main focus is workers' comp. And I just want to speak real briefly on 101, which I understand hopefully you will likely take up at a later time, but and I've been following this discussion. I think it was on the 23rd when Damien did the walkthrough, and I just wanted to give a couple of comments today. I heard Senator Clarkson that day say, oh, this is a lot. And I understand why she would say that, because it's not a short bill. And I think there's 14 sections in it. The workers' comp piece that I'm interested in is sections, I believe, 1 through 6. I have to be honest, I have no opinions on rate of contribution or administrative fund pieces of the workers' comp amendments, but sections 1 through 6 are of great interest to me. And I did hear that comment from Senator Clarkson, and I understand why she said it. It does seem like a lot, but I hope I'm given further opportunity to talk to you at a later time to talk about it, because I think once we go through it, the truth is there is not a lot of change here. It's simply codifying existing practice, clarifying current statutory language, and in a couple of places, reasonable common sense updates to the Workers' Comp Act. For example, in workers' comp, when an injured worker is out of work, they're entitled to a dependency benefit. And if they're out of work for the injury, they're entitled to a dependency benefit, which currently is $10 a child, and it's been $10 a child since 1981, when it changed from $5 to $10 a child. So we're seeking to, in support of that being updated to $20 a child. There is a provision in the act already that limits
what per week.
Yes,
Okay.
yeah, when they're on the temporary disability
Yeah.
benefits. And there is a provision in the statutes already that limits how much somebody can get when they're out of work. So if somebody, had 10 children, there is a limit on what their benefits are based on what their wages were before the injury. So that's kind of a common sense, reasonable change. There's another change that I had testified in a House bill right before COVID hit. I remember it was crazy. We were all crammed in one of these rooms and people weren't wearing masks yet, but it was clear that everything was changing very soon. And so 3 years ago, I was in support of this same legislation, which is a proposal to change the way temporary partial disability is calculated. It's a very small subset of injured workers, but these are people who are still treating for their work injury, but are able to do some work. And so they're working part-time and they get a supplement from the workers' comp carrier. There are a certain number of lower income Vermonters for which, if they're in that position of working part-time and getting the supplement from workers' comp, they're actually getting less money than if they were out of work completely. And that just disincentivizes injured workers to want to get back to work. And I think just common sense wise, it shouldn't be that way. Somebody should not be getting more money being out of work completely than working part-time and still recovering from their injury. I'll just mention a third of the provisions that are in this bill is about the pre-authorization statute. You folks 10 plus years ago passed a statute on pre-authorization of medical treatment.
Mhm.
And this was very helpful. Basically, if an injured worker needs a surgery, there was no way more than 10, 15 years ago to be able to force the workers' comp carrier to make a determination, yes, they were going to cover this surgery, or no, they're not. And it could sit in limbo for a long time. So the pre-authorization statute was created a little more than 10 years ago. It's been very effective. But unfortunately, it doesn't actually apply to all the medical benefits that a claimant could be entitled to in workers' comp. So the big example I can tell you is what are called DMEs, durable medical equipment, a wheelchair, for example. Right now, under the law, if an injured worker's doctor says they need a wheelchair, there's no way to require pre-authorization consideration from the workers' comp carrier. So the many carriers actually will approve those things, pre-approve them, and the injured worker gets them, and it's great. But there are certain carriers or certain defense attorneys who, just because they can deny the pre-approval request, will deny the pre-approval request.
Mhm.
And so for injured workers that don't have the money to pay out of pocket and then get reimbursed, seek reimbursement, or don't have the money to pay out of pocket and possibly not get reimbursed, it's really important that this pre-authorization statute is amended to basically cover all the medical benefits that could be available to an injured worker. I wanted to note Senator Brock in that walkthrough on the 23rd had a good point about one of the words in, I think it was page 7, right at the end of section 3, and this is about the temporary partial disability and when payment has to be issued by. And Senator Brock, you rightly pointed out, submit is kind of open to interpretation. What does that mean? Is that in the mail? I agree that should be tweaked to be based on the carrier's receipt of the information, that it's the receipt of the information that then triggers the 3-day deadline to get the payment out. The last thing I would just say, again, I'm happy to go into further detail. I just wanted to give kind of a broader view of it, but there needs to be a change to the current scheme for penalties issued to workers' comp carriers if they issue payments late to injured workers. This is very important. There is a late penalty in the law right now, and it has no teeth. It's so small that carriers are not changing their behavior. I can honestly tell you, I probably have half a dozen clients a week who do not get their payment that they are due in workers' comp because it's fallen off of auto pay, is what the carriers call it. And even a day or 2 days late for these people is the difference between bouncing checks and getting overdraft fees. They're depending on this money. And even though there are some penalties in the law right now, they're not changing carriers' behavior. So the bill does seek change in the penalty structure. I guess that this may be the most controversial for the other side, perhaps, to look at. But I have to be honest, if carriers are doing what they should be doing, it's not going to cost them any more money.
Right.
It's only when carriers are messing up and not paying people on time like they should be that it's going to increase costs.
And many of us face penalties if we're late.
Absolutely. I mean, and that's the thing, the penalties that are due to an injured worker don't cover the actual penalties that they are incurring from their banks or for whoever. I get electricity disconnection notices. I have to write letters to landlords. No, there's money. This is a compensable claim. It's just late. It would be really wonderful to have a stronger penalty scheme for carriers to pay attention and make sure people are not falling off of auto pay. I'll also just put in that we've been having ongoing discussions for the last several months with Director Anderson. It's been helpful to kind of touch base and discuss these issues and have an open dialogue. And I just really look forward to coming back and getting into the weeds a little bit more with you folks.
Great. Senator Clarkson.
Thank you, Kelly. Anyway, I won't question if it was 1981 when the child benefit was last updated. What was the date for the last update on that penalty?
Oh, that's a good question, actually, and Senator, I don't know that offhand. I apologize.
I think
But I
it
can
would-
certainly look it up.
I think it would be great with all of these, if they sound like sort of common sense updates, as you put it, which is, I think, a good way to look at this bill. It would just be great we can get this from Damien, just to get a sense of the year that they were last updated, so that we get a notion of.
I think,
I mean, Damien's a bit beleaguered with everything that's going on, so if you have any answers for us.
absolutely, I can shoot you an email, sure.
Yeah, that would be super helpful. And
I agree. There's a lot here in the bill, but honestly, a lot of it is reformatting, which Damien, recognizes needs to be done when he's working on a bill. There is the codifying existing practice at the department and just clarifying some of the language that's existing already in the statute. And then these common sense, reasonable tweaks, I believe, are really necessary.
Great. Thank you.
Thank you all, and hope you come back and
Yes.
speak further on it.
Absolutely. And that's after crossover, but
Yeah.
I really appreciate this, so we
Yep.
understand this piece of it. Austin, we tried to get you a few more minutes, we were unsuccessful, but appreciate it.
But right on time with the original.
Yeah,
Yeah.
that's something.
Good.
Yeah.
Yeah.
For the record, Austin Davis, Director of Government Affairs for the Lake Champlain Chamber. Not a lot of time, even with 15 minutes. I wasn't sure. I'm prepared to speak about all four bills. If there's a particular order you want me to go through.
Well, you may have started to hear that UI workers' comp will carry past crossover when we get other bills. And so we'll have more of an opportunity for people to speak after that.
Okay.
Some pieces of the other bills we hope to get through by crossover. I already said out loud that, good cause termination seems like the one where a lot of people want to speak on either side, and it may either get narrowed or take longer than for crossover. So that's
Okay.
where we're-
Yeah, I'd certainly say that I think good cause is something that we could probably spend 6 legislative months on instead of 6 legislative days. It would certainly make us an extreme outlier in the United States to move from at-will employment, and I think there's a plethora of witnesses that should probably come before that. I think there are very few bills that we sit in this chair and say flat out no. This is one of the few that we'll say is a kind of a non-starter for us. I don't know if you want to talk more about specific items in the bill that are going to move forward. I apologize, I've been in House Commerce this morning
Okay.
to follow closely what.
I suppose if we go from 101 to 102, which is the worker protection, and civil rights. Yeah, and so 102 is.
Go to
pro-
101.
Yeah.
So from
101 is coming after crossover. So.
Okay, and so then 103 was the other one?
Okay, 102 is collective bargaining rights. It's,
That's the at-will.
that has that piece, and it
Yes.
has domestic and agricultural workers and captive audience.
Yeah, and I think, we just are opposed to the language that's in the bill. I think the captive, yes, yeah, and I think the captive audience needs more scrutiny. I think that's the one I'm least prepared to speak on today.
Okay.
I'd have concerns about, I think David in his earlier testimony discussed, even just explaining, even just explaining what a relationship would look like under a unionized environment could trigger the language in the bill. And I think that's a simple enough thing that an employer could be forthcoming about, and just understand if an employer solicits that language. I worry about that language. I'd like to take more testimony from expert witnesses other than myself on that, but I think
Okay.
we're very hesitant to it.
Okay.
I think broadly, S102 would be a major shock to our state judicial system. I think the courts or our AG would be ready for many of the provisions in the bill, trigger a lot of litigation potentially.
Aside from good cause termination, is there a specific piece that you think would cause a backup in the courts?
I think just generally moving to from at will would be
So that piece.
dramatic. I think the whole bill on its whole, we're just very concerned about.
Okay,
And I don't want to take any one portion of it to be, I don't think we take any exception to any one portion of it. Constructive discard.
Senator
Discharge.
Clarkson.
So, Austin, thanks. I guess I mean, I understand this is a just cause or good cause, giving cause is a bright line for you guys. And I'm just curious, I guess I just don't get why. I mean, all of us have to give our children reasons for why we do. I mean, we give reasons all the time for why choices are made. I would just love to know, from get a really strong illustration about why that's a difficult thing for business, because, what percent of the time is it personal and it's hard to make that call publicly, or, what percent of the time is it just you're not doing the job, or you're not capable of doing the job, or it's, to me, this, I understand it's a problem for you, but I'd love to know really why it's such a big problem for you.
I think it'd start with that, and if you don't mind, I'll put it this way, it's just kind of difficult to frame in there. Shows like in House Commerce where it's
Weird.
It's okay, I can see you, Austin.
But I think, making the state an extreme outlier is just first and foremost an extreme concern. I think when we talk to many of our businesses, they already feel as if they deal with a different climate environment in this state than they would in other places. And there's a significant amount of work that's done to try to keep businesses here and have them think this is a good place to do business. Saying that we're unlike any other state in the union is not a good starting place when it comes to this. I think, as I said, the constructive discharge language is very broad, and the provisions in the bill, as I read them and as employment attorneys I've spoken to read them, talk about failure to do the duties of the job, making that it's a reasonableness standard that would fall before during litigation, when really it should be about satisfactory performance for the employer and by the employer's assessment, saying that we're going to try to look at a comparable outside of that particular business or employment environment is just really not productive, and makes it just very difficult for employers. There's also extensive language in the bill around just economic conditions. I think that those are very difficult to navigate in the world that we live in. So
Okay, so you could bring in an attorney or an expert if you want, post crossover as we continue that discussion. The Lake Champlain Chamber opposes the organization of domestic and agricultural workers.
I think that's the one piece of the bill that we have really no real opinion. We don't do much work
Okay.
around,
Okay.
domestic and agricultural workers in
Okay,
our organization. So I should have mentioned that with exception, but my prepared testimony has nothing on that.
okay. I just wanted to be clear because you
Yeah.
said you opposed the whole bill, and I was like, I would love to hear your concern about that.
Yeah, that is something I will leave to other folks.
Okay,
Uh,
Senator Cunningham.
I'm just really confused about. Actually, I always thought Vermont was an outlier for no cause.
Yeah, being at, well, I always thought that too. I thought that-
Yeah.
As I understand it, only Montana has, no, it's the only state that doesn't have at-will employment in the country.
But
Nope, sure.
I guess the balance were, there's a difference between saying, I just don't like you. I want you, my cousin needs a job, you're gone. And saying, you're making me uncomfortable. You're asking, you're working to unionize, or you ask questions, or you're not. And you think I guess what is the problem with having to give a reason to fire someone?
Well, I think that there are reasons given, and I think a lot of the things that you mentioned are protected in statute in various ways. Like I said, I'd highly recommend, I'd recommend that you folks hear from an employment attorney. I think attorney from Paul Cranston Collins, Stephen Ellis has some opinions on this and has indicated he'd be interested in specifying when you folks return. I don't think it's as simple as just giving a reason. I think reasons are given when folks discharge often.
Well, that's what
I think
I'm
it's many of
thinking.
the provisions within this legislation are incredibly prescriptive around how discharge can happen.
So we might make it less prescriptive is one of the narrowing.
Well, I think that can be done in a way that doesn't throw away at-will employment entirely. There are specific instances that this bill is looking to protect or remedy. I'd love to hear those. We haven't really heard. I'd be curious to hear if there's specific instances this is seeking to remedy, or if this is just trying to change our employment environment entirely.
I mean, I'll throw one out, which is termination during a period of unionization or the decertification period after, where it's like.
So it sounds like, you know, you want to work on some of the issues around captive audience, and that sounds like that might get pushed into other legislation, but that might be something to address more prescriptively than a.
But you might also fire the people who are leading the organizing efforts without a real reason shared. That's kind of the problem we've heard, one of the problems.
And I think, I mean, in current, and again, I'm not an employment attorney, I think in current statute, there'd be protections in terms of that being but if there's evidence that's a retaliatory effort, those individuals could, you know, would be open to remedy. There's rights there.
Okay, so that might be one where you're willing to support if the language is strong enough.
I think we'd have to look at language and, you know, like I said, I'd love to hear from other employment attorneys.
Okay, do you want to go to 103 about workplace discrimination? Darken my door.
Yeah, so we've had a robust conversation about that upstairs in House General before. I think broadly, the changes to existing language around this are problematic because it kind of just, it redefines harassment as a single event, then other than what happens under existing case law. So right now, under case law, you could have a severe event or a series of pervasive events. And if you would be looking to clarify existing case law and statute, say that it need not be construed as severe and pervasive, which I understand is a misconception that's out there, that it's an and rather than or. It's important that it's an or. We could understand that. However, as written, the language creates a situation where it's very difficult. It potentially makes, you know, our court system, our Attorney General's office as kind of a supercharged, all-powerful HR office where single incidents go there before they go through an employer process. And so I think that there's concerns around that. You know, something that might be, say, a microaggression, if you say it need not be severe or pervasive, you know, could be elevated to what would be beyond, seen as in this new territory, beyond a petty slight. And then you end up in a situation where the employer has had an opportunity to remedy and you jump straight to litigation, or you bring it straight to the Attorney General's office. So that would be a concern of this. I think that many of the employment attorneys that are on either side, employer or employee, told me that the severe or pervasive language that's currently used in court is important. Because I mean, you think about this in the context of a workplace incident. If you have a single severe incident, that certainly warrants moving forward towards legal remedies. If you have a number of pervasive, you know, issues, that certainly warrants it. When you say that it doesn't have to be either of those things, what does that leave? And well, the bill does have language to say that, you know, a petty slight shouldn't be construed as this. There's not a lot of daylight once you remove that. So
Do you have a witness that you'd like to have heard on
I
that?
think it'd be great if you heard from Karen Stackpole from Paul Franklin Collins.
Okay.
She had fantastic testimony about this and House General, and is very adamant about this. We worked on both sides with employers and with employees, and has really strong opinions about how to build better workplace culture around reporting, pervasive issues, petty slights that could be perceived as more than petty slights, and how to just build a better HR environment.
So we're short on time.
Do you want me to just hit the no rehire provision real quick?
Sure, and then I was gonna say you may wanna either talk to Scott about witnesses or offer something written on non-competes and minimum wage.
Yeah,
Minimum non-competes is in this bill, and minimum wage is looking like a post crossover bill as well.
I'd love to also come back and talk on a more robust discussion about this. And I think on the no rehire provisions, I'd say listen to Rich Cassidy on the employee side and Stephen Ellis again on the employer side. Those two in the House during testimony on this were actually uniquely in agreement that you shouldn't touch the no rehire provisions. They both were in agreement that these actually help the folks who in settlement of a claim. For the employer, it provides a degree of closure. For the employee, they can kind of extract a premium. And generally, if you're at a point where you're litigating something like this in court, the relationship is sour to such a point that it just makes it easier to say, we're going to walk away from each other. They've had some constructive conversation around how to make these so that they might not be in perpetuity, how they might be more refined to certain departments if it's a larger employer, how it might not but one of the assumptions for advocates of these kinds of provisions is that these are somehow coercive in nature. And it's actually further from the truth. Generally, when you have one of these agreements added into a settlement, you're dealing with two attorneys sitting down and hammering out a final deal. So it really does extract a premium for the employer and present some, or extract a premium for the employee and provide some kind of closure and finality for the employer. And then finally, the non-competes. I would just say, we talked about this for the last 4 years in the House. It's been a really robust conversation. I'd certainly welcome in the Vermont Bar Association. They actually last year tried to come to a consensus on this and couldn't. It speaks to how difficult this is. Really, though, I think from our perspective, the best thing to do would just be to not pursue non-compete legislations here and let the Federal Trade Commission continue their regulatory process on this. They actually just went through an initial comment phase and are in rulemaking right now. Whatever the FTC comes out for, and the Biden administration has made it a key component of their priorities in the next few years. Whatever the FTC comes out with, we're going to have to be following the supremacy clause.
And that doesn't have to go through Congress.
That doesn't have to go through Congress. This would be a rulemaking procedure so I think, to my understanding, I think following their lead, even if they are doing something that then requires congressional action, picking up what their recommendations are, rather than using our finite legislative time in the state of Vermont might be a better use of that, because we've engaged with a lot of professionals over the last 4 years on this issue, and it's very hard to build consensus around it. I think non-compete agreements are really important implications around legal gray areas. And I also think what's lost in all this is just the important ethical component of it. All of you as legislators have an ethics agreement that closely mirrors a non-compete agreement. So you're all agreed to not pursue any lobbying endeavors within the state of Vermont for the period of 1 year after completion of service. And that's actually a great example of a well-written non-compete agreement. It's narrow in what it's focused in. It has something it's trying to protect. It has a confined geographical region and a well-established amount of time, and it's linked to consideration. That's an important thing that's lost. Actually, my family, ironically enough, is listed in some of the major case law around non-compete agreements because, which this language thankfully already has this, but there was an instance of an employee taking an employee prospective business list and going out soliciting in a new territory that my great grandfather was looking at in Southern Vermont many, many years ago. But I think it's a really complicated issue, and I think it'd be great to let the FTC lead on.
Okay, thank you. And then minimum wage will take up later. So.